este minuto está habilitada la traducción. Ustedes tienen que ir a la parte inferior de la pantalla de su computador, donde van a haber 3 puntos. Ahí ustedes pinchan y ahí les va a aparecer varios iconos. Uno, un globo terráqueo que dice interpretación. Ahí ustedes pueden elegir inglés, español o lo que sale del micrófono. James already has been on the interpretation button, so hopefully it's good with you. And with no more delays, I will leave the floor to Alberto for the opening remarks.
Thank you, Luis, but that will be Maria de Los Angeles. And so we should start recording for, there we go. We're recording now. Maria de Los Angeles.
Okay, so no more delays. Good morning, everyone. We apologize for the technical issue that occurred. These are kind of things that sometimes happen in public universities. And well, thank you very much for your patience. Welcome again to this webinar on considerations for an exception on intellectual property in the development of AI. Good morning again to our panelists and moderator. Thank you for being part of this seminar. And of course, thank you again to the audience for your interest and patience. My name is Maria de Los Angeles Fernandez. I am a professor in the Faculty of Law of the University of Chile and a researcher in the Center of Studies of Law and Technology and Society. And if we have a little space, I would like to tell you a little about this center, since it is the home of this event. Our center has been leader and pioneer in research and teaching on law and technology for about 38 years. Our professors and researchers are and have long been active participants in public debate on these matters across a wide range of institutions and spaces. And we also publish the Chilean Journal of Law and Technology, an international indexed academic journal dedicated to disseminating debates within the legal community on different topics such as data protection, AI, cybersecurity, digital transformation, and other issues in the intersection of law and technology. And this is the second webinar we are organizing on this topic, this time in collaboration with the NGO Innovarte. And our first webinar was held 3 weeks ago and drew a large audience, sparking a very engaging discussion that kept everyone very interested through the 2-hour session. And I have no doubt today's discussion will be equally enriching. So I now give the floor to Maria Jose Arancibia. She is a professor at the Faculty of Legal and Social Sciences in the University of Talca. She will introduce our distinguished panelists and moderate the discussion and lead our Q&A. So thank you all, and I hope you enjoy this seminar.
Maria Jose, before we go to our moderator, we also had wanted to give some opening remarks as co-organizers of this event, mainly just to give the thanks al Centro de Tecnologías de la Universidad de Chile, de la Facultad de Derechos, que tengo que agradecerle a Alberto, que cuando le propuse hacer este seminario, inmediatamente se entusiasmó y puso a todo su equipo a trabajar, así que muchas gracias a la Facultad de Derecho y a la persona de Alberto. También aprovecho de presentar muy brevemente a la Corporación Innovarte, la ONG, que es una ONG que está especializada desde ya del año 2008, trabajando en temas de propiedad intelectual para el desarrollo y protección de la libre competencia. En ese contexto somos una organización que trabaja como observadora de la OMPI o la OMS, y también trabajamos en la OMC. Y de esta perspectiva nos damos cuenta de la importancia que tiene generar un debate informado desde la perspectiva no solamente nacional, sino que también de actores globales, como son James Love y Sean Flynn, que son actores muy relevantes en el ambiente jurídico en Ginebra. Así que también aprovecho de agradecerles esa atención. Lo último es como un disclaimer, en el sentido de que nuestra organización en el pasado y actualmente también trabaja por potenciar una agenda de excepciones de derechos de autor en la OMPI, lo que nos pone, digamos, en el lado de quienes nos gustan las excepciones como instrumentos de equilibrio. Y por el otro, también nuestra organización ha llevado una campaña muy intensa para pedirle a los gobiernos que pongan controles a los abusos de las grandes plataformas. Incluso nosotros presentamos una denuncia contra Google y Apple ante la Superintendencia Económica de Colombia, justamente por abuso de posición dominante. Así que tenemos estas dos áreas de trabajo que nos permiten conocer el tema, pero también debe ser informado en términos de la transparencia de las opiniones que yo voy a dar al final del panel. Y sin más, muchas gracias de nuevo, María de los Ángeles, por tu bienvenida y damos la palabra a nuestra moderadora.
Thank you, Luis. Good morning, everyone. Welcome to this seminar organized by the Centro de Estudios de Derecho, Tecnología y Sociedad of the Faculty of Law at the University of Chile. Today, we gather to examine one of the most pressing questions at the intersection of copyright law and technology. Whether and how legal systems should provide an exception to copyright protection when copyrighted works are used to train artificial intelligence systems. This is not merely a technical or academic question. The answer will shape who controls the future of knowledge, who benefits from AI innovation, and whether the global South will be a rule taker or a rule maker of the governance of these technologies. Chile is not absent from this debate. Our current AI bill has already sent by copyright provisions removed during the legal process, making today's discussion timely and urgent. We are honored to have with us distinguished experts from the United States and Chile, whose work has shaped international and domestic thinking of these issues. The format will be as follows. Each speaker will have 10 to 12 minutes to present, followed by a moderate question and answer. I will keep the time for ask and question from the audience be submitted by the Zoom chat, and then we'll select and read them aloud. A little of context for this seminar that Chile copyright framework does not include a specific TDM exception. Any IA training using Chilean or foreign copyrighted works occurs without a clear legal safe haven. Chile proposed an EI regulation and has oscillated between including and excluding both transparent requirements and explicit TDM exception, reflecting that the political tension between the technology sector, rights holders, and the academic community. Chile is also bound by bilateral trade agreements, for example, with the USA, Europe, and various and different WIPO treaties that impose minimum standards on IP protection, and any exception must comply with the three-step test. It must apply only a certain special cases, not conflict with normal exploitation of a work, and not unreasonable prejudice the legitimate interest of right holders. So we start with our first speaker, with Professor Flynn. I will introduce a little to Professor Flynn. He's the director of the Program of Information Justice and Intellectual Property and the American University Washington College of Law in Washington, D.C. He holds a Juris Doctor from Harvard Law School, where he graduated magna cum laude and bachelor's degree in political science with honors from Pitzer College. Professor Flynn's career has been defined by a singular commitment, ensure that intellectual property law serves to the public interest, not only right holders, but also researchers, educators, and users of knowledge worldwide. Professor Phil, you can start your speaker.
Great, thank you. Thank you very much for having me here today. It's quite an honor. Thank you especially, oops, I'm sharing the wrong screen. Thank you especially to Luis for inviting me, from Alberto. It's great to see him after such a long time. We used to share a city as well as an occupation together. Let me go over to, here we go. I'm just gonna turn on my slides a little bit and address this topic. So the question, I understand that Chile is discussing possible exceptions for AI uses, and I think one frame of the question, as Maria noted, is should Chile have an exception? But I think I want to complexify that a little further and assume that Chile is going to have some kind of exception and really kind of tease out some of the factors that could be considered in creating that exception. Let's see if I can get my slides moving here. Here we go. So the AI industry, it's extremely new. It's built on top of the existing internet industry, which has already received a level of concentration in the world, and AI has really aggravated that concentration. So if just as a starting point, if you look at kind of a map of the world, this is one version. It kind of depends on what kind of AI models you look at. But if you look at various kinds of large language models around the world, you find that essentially it's US and China who are dominating this field. There's a very small number of AI models being built in other countries. And as most of you know already, these AI industries are already massive. So, I mean, we'll probably have 3 initial public offerings this year that'll each create companies worth over $1 trillion. And so there's massive concerns around the world around wealth and value extraction that is being funneled through these companies. And so that brings out a number of policy issues for a place like Chile. I know a lot of the debate around the world is around remuneration issues and how do we use copyright to maybe force companies to compensate for the use of materials that are used to train AI programs. And that's often an extremely legitimate concern. But another concern needs to be, and I think Luis introduced this a little bit, how to foster competition. So can we be users and producers as well as users of these systems, and what are the kind of circumstances, and especially copyright circumstances, that are going to allow a proliferation of models? We know that these models are largely, the models that exist today are largely trained off the raw internet, which means the values and culture they reflect are the internet's values and culture. So it tends to be highly fragmented. It's essentially a mostly English language culture. It reflects much of the culture within the United States. And so you have a lot of problems with bias, both kind of racism that seeps into these systems, but a cultural bias. People don't reflect their own cultures all the way around the world within these systems. And so there's a response to that we should have an enabling environment that allows many, many, many more cultures to be reflected. Some people have said there should be an AI tool, as many as there are countries in the world. But even if AI tools essentially reflect culture like a language reflects a culture, then you could think we need as many AI tools as there are languages in the world. And there are thousands of languages in the world, but there aren't thousands of languages on the internet. So how do we kind of move to a point where there are AI tools that reflect different cultures around the world, not just a monoculture? The current environment, you can kind of break into two big developmental models. There's a third one, which is really China, which I don't feel I have enough expertise to really describe. But if you look at the US model, the US model has been built on the copyright side on the back of the Fair Use Clause, which is a flexible multi-factored test. And basically the determinations of whether specific AI uses comply with copyright law are before the courts. And I'll refer to some of that litigation in a moment. In the rest of the world, we refer to kind of the middle powers, and in the middle powers in AI, it's essentially everybody that's in between China and the US. You tend to have more specific exceptions. There are some countries that have adopted fair use, but most countries, especially in the civil law tradition, especially in Latin America, have specific exceptions. Chile is certainly one of those. It lacks kind of a broad fair use clause. But also the dynamics of who's doing AI is very different. So in the US, it's completely dominated by private companies. They're massive private tech companies that have access to enormous amounts of capital. And so they're using that private investment. They're building data centers all over the US. They're reaching licensing deals. They have massive numbers of engineers, et cetera. And the models they're building are primarily being built for profit models. They're trying to find ways to profit maximize through this new tool. And they're doing it largely through closed models, meaning that those models themselves are protected by intellectual property. They're not being shared with others. They're not openly licensed. So they're building models each for themselves. But in the rest of the world, you see experimentation with a different form of development. Many people are calling it public AI, the idea that we should treat artificial intelligence as infrastructure. And part of that infrastructure is to build models that are more open, often through public initiatives, often based at universities, and to try to build tools that can then be built on by others. So in the AI field, we talk about foundation tools, which are these really large language models that can be used for many purposes. But then you can build smaller AI applications based upon those tools. But you need those foundations as starting blocks. So there's this policy question of, should those starting blocks be closed or open? Should they be public interest, public infrastructure, or should they be privatized and closed? As I mentioned, in much of the world, that more public model is being used, public investment, university resources, et cetera. And in Chile, you have the model of LATAM GPT, which is itself trying to build a model based on Spanish language materials from Latin America, especially South and Central America, and to try to express their own model that can express, Latin American cultures. And just taking some of the information from their own website, you see that what they're trying to do is gather materials through sharing through various universities and different knowledge repositories to build a shared database of specifically Latin American materials to train that model. If you actually look, they've assembled something like 2.6 million documents. That's actually incredibly small. Some of the Google and Anthropic and these large language models are trained off of billions of documents. So there's a much smaller set of data that's even being used right now in the existing LATAM GPT project. As I said, it's, most of the partners that are engaging are public sector partners, they're governments, they're universities, etc. But so, one of the reasons that the resources for a project like LATAM G2ET, and we find this, throughout the kind of middle powers, part of the reasons the number of materials is actually fairly small that they're using to train is because the copyright laws in most of these countries lack exceptions that can be used for training AI materials. So text and data exceptions, research exceptions, etc. Just looking, and I apologize, I took the English version so that I could analyze it, but these are the sections of what I found to be Chile's current copyright law. I think I have the current version. It doesn't reflect the changes that I understand have been proposed in Parliament various times. But so you see their libraries are essentially restricted from making copies and sharing them, even with public sector research institutions that are doing public AI projects. Libraries are limited to either reproducing works that aren't available on the market, or making copies of fragments, or digitizing works but only allowing them to be used in the terminals of libraries, or translating works that aren't already translated into Spanish. None of these allows what's happened in the US, for instance, under the Google Books project, to actually copy entire libraries full of materials that are now being used to train AI tools. So in Latin America, the libraries are not working in the same way. So these people trying to find various kinds of documents have to find them in other places. If you go a little broader to some of the work we've done on research exceptions, for instance, this is a map showing how open research exceptions are around the world. And by open, I mean that you can potentially make a copy of the whole work as long as it's for a fair purpose, that you can use it for any kind of research purpose by any kind of research user and any kind of work. So many research exceptions around the world have various kinds of restrictions. They might only apply to chapters of books. They might only apply to scholarly articles. They might not apply to digital works or broadcast works, audiovisual works, etc. And you see a lot of the red countries with most restrictive actually occur in Latin America. The red countries only have a research exception that applies, like that Chilean fragment exception, to basically make copies of portions of works. And that's not enough to do to train AI or to do other kinds of text and data mining research. Text and data mining research is actually not only used just for AI, it's used by researchers for all kinds of research projects to digest books and search them materials and search them for various reasons. And just to maybe point out one, I mean, if you look at the green countries, which are the most permissive, they tend to be in the United States and a couple other of the more developed countries. That the more developing countries tend to have more restrictive copyright laws. And these are vestiges of colonialism. That, back in the days when copyright laws were received from colonial powers, the colonial powers often exported more restrictive versions of their laws than they even had in their own countries. And we haven't always changed them to caught up the fact. Now, there's a large number of AI reform proposals that deal with copyright issues being considered or litigated or proposed around the world. And so we at the Center on Knowledge Governance at the Geneva Graduate Institute, which is actually where I am now, are starting to kind of map these, and expressly for the kind of purposes we're dealing today is to kind of inform, if you're thinking about creating an exception, what kind of factors can you look at? And it doesn't have to be just an on-off switch, so that you don't have to just have an exception for copying materials to train AI or not. Actually, these exceptions can have many kind of different factors that can apply different exceptions to different kinds of uses users, the kinds of works used. And then it can also, and you see down the left-hand side, have different kinds of tools that apply. So copyright law is not an on-off switch. It's subject to copyright or it's not. You can have, for instance, opt-out rules as exists in the EU. So an opt-out rule basically says you are free to use the material unless the owner has said explicitly, has applied kind of a formality, has said explicitly that they don't want that material used. So you have that is the one of the primary tools within the European Union, for instance. In the European Union, they have two clauses, Article 3 and Article 4 of the Digital Single Market Directive. Article 3 says if you're a research user, so if you look down on the right-hand side, if you're a particular kind of user, if you're a research organization, a university, cultural heritage institution, you have the rights to essentially use all materials in your research project. But if you're not one of those entities, then you fall in Article 4, and you can use any materials that are not explicitly subject to an opt-out. These are primarily thinking about web-based materials, but so there's a number of tools that now exist where a website or a producer of content on the website can opt out, can say, I don't want my material used in the training of AI or in a text and data mining project. So that's an example of distinguishing based on the type of user. You can also distinguish based on the type of work that is used. So some of the litigation in the United States, for instance, the case against Anthropic had a dual decision at a lower court level. So on the one side, they said that the use by Meta of pirate libraries to create or by Anthropic to create pirate libraries of materials that they'd never purchased to create libraries to train their AI tools was not fair use, was illegal. But then in the same ruling, they held that the use of purchased lawfully accessed materials to train their same AI was lawful, that it was highly transformative. And so it distinguished based on the types of materials that were being used in the training. The Voss report, which is a report of the European Union Parliament, for example, proposes, it's not law, but to treat journalistic works different than other works. And the reason is because there's a fear in that report that journalism will be substituted for by AI, and that people will go to AI instead of going to newspapers, and there'll be a large loss of income. So they propose to treat those kind of works differently. One of the key copyright factors which exists in all copyright laws is the substitution effect. Maria mentioned the three-step test and the protection of the legitimate interests of the author. And that's primarily analyzed through whether the product of the use is substituting for the work that is being used. And so there's been cases there. You have the New York Times case that's being litigated in the United States as a claim that the AI tool is memorizing the New York Times and spitting out the New York Times. And so there's a direct substitution for the AI output and the content that is being mined. Or there's a case in the United States, the Reuters v. Ross case, where a company went and mined legal books with have headnotes and descriptions of the law in order to create a competing legal tool that had its own descriptions of the law. And the court said, no, you're using a work to directly compete with that same work, so that's illegal. So Substitute to Mexico has recently passed a law that primarily focus on mimicry. So there's a lot of concern in this area about mimicking performers, mimicking voices, mimicking actors, etc. And this is a kind of direct substitution for the work that's being mined. So that substitution factor is often incredibly important. And then, of course, the purpose of the use. Is the purpose of the use commercial, non-commercial, research, or not? And under each of these steps, you can take each of these factors and then you can run down and say, okay, what tools shall we now apply? Maybe for some things, there's such direct substitution that we want to have complete copyright control. But in others, you can start moving down that chain of tools and say, okay, maybe we should apply opt-outs here, like the EU does for commercial uses of AI, but not for research uses. Or you could have statutory licenses. So instead of requiring individual remuneration and transactions and negotiation, you can say, okay, we're going to have a statutory license like the US does for radio play. If you play music on the radio in the US, you don't have to negotiate, you don't have to ask permission, but you do have to pay. But you pay a regulated rate. You don't have to negotiate and pay the exact rate that the holder requires. There's also a space for access controls, technological protection measures in this world. So if you say that a company can protect their access to their databases with technological protection measures, then that is often enough to force licensing. So you actually have licensing of Wikipedia content. They have all of their content is free. But if you're an AI producer and you want to access their content more quickly and more directly, you can actually pay them for it. So the point is that there's a huge number of different factors that could be considered. And one could use these to kind of write a more complicated exception that might provide different rights for the kind of researchers that are building tools in Chile than you necessarily give to Google, big tech companies, etc. And so this is one of the graphics that we've kind of created in our work on this issue, but it just tries to boil that down. And it's not meant to be prescriptive actually, but as one, there's a series of factors that might drive you more towards the higher level of full protection and others down to access. And we've discussed a lot of them. The more you're making a competitive product, creating substitutes, engaging in direct competition, then both through the 3-step test and just copyright and development policy, you might want to move higher up the protection chain. But the more you're a public interest actor, a public actor, a university actor, research actor, creating non-competing goods, trying to serve the public good, trying to answer new questions, development questions, etc. I think there's a real need to carve out space for these uses. The really interesting area in between all these is the creation of kind of public foundation models that can be used to either create commercial or non-commercial tools. And so what a lot of scholars are trying to figure out in that model is ways to make various kinds of remuneration and protection turn on the output rather than on the training. So if you're using that foundation model to build a music machine that's going to compete on Spotify, you could treat that tool differently than a research machine that's trying to solve new problems or translate things into new languages and all the different uses. So I'm gonna end there. But I think, the point is the end point is the same as the beginning, which is really this is an area that calls for a really multi-factored analysis. And there's a lot of different, very important factors that need to be considered in order to tailor policy to all of a country's local interests. Thank you.
Thank you so much, Professor Flynn, for your presentation, and it was very clear and thought-provoking with your different comparison of legal systems, and your graphics are very important to our audience. Now, I have to present to James. James, sorry.
Oh, I'm here. Can you hear me?
Yes, I hear very Well, our second international speaker is James. James is the director of Knowledge Ecology International, a non-government organization with office in Washington, D.C. and Geneva, dedicated to attending and mending the knowledge ecosystem. His academic training is an economistic and finance. He holds a Master of Public Administration from Harvard University, Kennedy School of Government, and a Master of Public Affairs from Princeton Woodrow Wilson School of Public and International Affairs. James, the audience is yours, please.
Thank you very much. I'm going to speak without slides. I've written something up which I'm happy to share later, but I'm just going to kind of walk you through it. And Sean did a great job, I think, of beginning the seminar, and he covered so many topics, and it's going to make it much easier for me in my presentation. I think from my point of view, when I approached this, I was aware of the fact that in Chile, there had been a proposal by the government to have a very robust exception for training AI, and that it met resistance from copyright holders, and the progress has been blocked because of this dispute. So I really focused on how you sort of address these issues. I think the fact that Chile is trying to develop its own domestic AI industry is pretty important. I mean, like the United States, a really big market. European Union is trying to create a big market within the union. Chile has a population of less than 20 million people. You're the 5th largest economy in South America and the 43rd largest economy in the world. And in terms of population, in terms of your GDP or your gross domestic income, you're a little larger than Nigeria, even though Nigeria has quite a few more people. But still, scale is important, and because of that, you have to approach this in an environment where you want your companies to be able to reach scale in terms of the services they provide, but you're not really in the same position that the United States is, or the European Union is, or China. The global market for generative artificial intelligence, or Gen AI services, is really blowing up. But the future really remains speculative. It's speculative in terms of how big the market actually is going to be at the end of the day, but also the types of services that are provided. Most of us really became familiar with the large language models like ChatGPT or Gemini or Claude or things like that. But the thinking is that there will be a proliferation of agents which are more narrow and specialized. Will be pretty important, and they really have different characteristics. Not everyone, not every profession, not every industry has the same interest in changes that they will make throughout the economy, and that makes it really challenging for policymakers. One thing that Sean, I spent a fair amount in the later part of his presentation on was distinctions you make in the types of data that could be used to train AI. And we've focused on that. I wrote an article once for a couple of years ago for Scientific America, where we made the argument that works of a technical nature should be treated different than goods or articles that were more for the cultural industries. So we said that you would treat musicians, you treat literature and things like that different than you would, for example, scientific articles on biomedical research. Just to illustrate two kind of polar examples. And when you really talk about data, in addition to those kind of distinctions, which are made actually in several norms, if you look at the Berne Convention, the appendix, and even the regular exceptions, they make distinctions on the types of works, and they have different kinds of rules for them. Photographs are treated differently than music. In the appendix to the Berne, they make a special distinction for works of fiction and poetry and cultural works on the one hand, and technical works on the other. And you see that, and Sean gave a number of other examples, but that's really important. Also, whether or not the works are actually commercialized is really important. And one of the problems in copyright is that the most powerful lobbyists are people that represent works that have commercial value, but they set rules that apply to everything. And so if you're a user of data, you're confronted with all kinds of liabilities, works that are really not being commercialized at all. And so you know, this is sort of the orphan works problem. You've got like a huge number of works that nobody even really knows who the owner is, or the owner, you know, or that information is possible to find, or no one's really commercializing it, but you can't really use them without the risk that you would be sometime hit with big damages. And so one thing I think is important in AI is to the extent you're going to compensate or remunerate owners of works, you narrow it down to people that really care about the commercial nature of the works, and not just everything that covered by copyright, because everything covered by copyright is a lot. I mean, if you look at the things that I write, I write a lot of things on informally. You know, I put them on listservs, I put them on blogs and things like that. I never expect to see any money from those things. But there's other works that people do where their livelihood depends upon it, and I think these things really have to be taken into account when you talk about remuneration models. There's works that are protected by copyright, and there's a lot of data that's not protected by copyright at all, but it's used to train AI. One of the areas I work on is in traditional knowledge, and there the rules are really kind of a mess right now in terms of you know, in very country, but also you have data, which are facts, which are a lot of times not protected at all. Works by the government, some legal documents are not protected, other things are. So those really present different challenges. I want to focus a bit on a couple of things I think could be kind of interesting models for how you might remunerate people that care about the money that's involved in their acts, and really are the most aggressive lobbyists on these issues. But one is to sort of look at what happened in Europe with the EU directive on copyright in the digital single market, the DSM directive, and particularly Article 15 of that directive. That's the so-called, that's a directive that created a special sui generis right for publishers of press information. They created a right to be remunerated for publishers, not authors, but publishers of pressing. And they made a distinction between what qualified as a press publication. They explicitly excluded scientific and academic articles, and they explicitly excluded independent blogs and websites. And they also excluded foreign non-EU press publishers. So they designed it so the only beneficiaries would be press organizations in Europe. And like a Chilean newspaper could not legally demand statutory compensation from a search engine for using its data or providing kind of summaries of its information. But like a European one too. So one of the issues that comes in terms of how you might compensate people in Chile is you want to compensate everyone that might have a copyright claim, or only people that are Chilean copyright holders. And in the way they approach this in Europe, when they created a special, another thing I would mention is in Europe, they try to create a sui generis right, an ancillary right, or a related right, instead of relying entirely on copyright, because copyright has a mandatory exception for quotations. And they didn't want the search engines to be able to rely upon that exception, so they created it as a separate. Also, the copyright laws have a lot of conditions on national treatment, and Europe wanted something that discriminated against foreign rights owners, and they didn't want to have to worry about the copyright, the quotation exception in copyright. So they created it as sort of a related right or a sui generis right, which was different. And like one way you can think about this, if you create a robust exception to copyright for training AI, you can couple that with a sui generis right to remunerate certain beneficiaries in Chile that you want to benefit, that you want to remunerate. You don't have to call it copyright remuneration. You can call it like an ancillary or a sui generis right for training AI that only applies to some people and not others, just like the European directive only addressed certain copyright owners, but not everyone in Europe. So, so you could do the same thing. You could, for example, have a thing where through a regulatory thing, you could identify potential beneficiaries based on like residency or whether they're considered a Chilean entity. But you could also limit it to certain kinds of works. You can even require formalities and registration and things like that, which you really can't do right now. Now, for a lot of copyright owners, it depends on the area, but for some copyright owners, registration is not a huge barrier because they're depending on how it's done, because they're already trying to work with collection societies. So they're already trying to provide metadata to collection societies in terms of getting paid through them. It doesn't really apply for everything, but I think this sort of idea that formalities is a bad thing it should be rethought in the world of AI, because you're trying to manage, you're trying to identify whether your data is being used to train. You're trying to help the people training AI to know whether they're like who the right owners are and the data that they're trying to access. You're trying to make more efficient whatever remuneration schemes you have. Sorry about that. That's my landline. Forget it. So that's one sort of line of thought. I'm going to skip on to something else right now, and that is that I do want to mention that one of the problems in training AI in Chile is not just copyright; it's also the privacy laws, and that's actually needs to be addressed at the same time. In that respect, I think it's interesting to look at the European Health Data Space Regulation, which is designed to provide access to data to train AI in Europe. And in the health area, privacy is a really important part of health records. Some of the records that are included in the Health Data Space Record are, well, one of the items which is huge is every single patient record is included in that regulation. And it's very sensitive data in a lot of cases. And there's other data which is of a confidential business nature that researchers have some access to, but it's controlled in a certain way. The way the European Health Data Space Regulation works, because it's dealing with all these issues of privacy, and in some cases intellectual property or confidential business information, is they create intermediaries that are trusted intermediaries so that the researcher can run queries on the data without getting access to the underlying records itself. So you can do research on lots of patient records without actually having the records in your own possession, and they would be basically managed by these trusted intermediaries. This is I think really an important innovation in Europe. It's also it's very significant that they also have an expectation in the European Health Data Spaces Regulation that that the data can be used for policy analysis, for training AI, and research and development on products, all of those things. It cannot be used for other purposes. It can't be used for marketing, for example. It can't be used to have or employment. So it has kind of a permitted use and an unpermitted use. But AI training is certainly one of them. And there's an expectation, although it's not really implemented in the regulation, that the product should be accessible and available on reasonable prices, or affordable prices, I should say, in Europe. It's a very European-centric thing. They see themselves as having a lot of data, and they want to sort of use that data through not just this particular regulation, but they plan to have more in other sectors of the economy to use the data to power the development of AI services, relying upon the data from 27 member states and 500 million people. Another set of models that I think are really interesting are those related to the access and benefit sharing negotiations that are taking place. There's actually quite a few that are going on. The first really was the Convention on Biodiversity, which set in terms of international norms. But and then they developed through that. There's the Nagoya Protocol, and more recently the negotiations of something called the Cali Fund. There's a recently ratified UN agreement on marine biological diversity in areas beyond national borders. That's marine resources beyond like where the countries assert sovereignty, called the BBNJ Treaty. There's a WHO Pandemic Influenza Preparedness Framework, the PIP framework. There's a FAO International Treaty on Plant Genetic Resources for Food and Agriculture. There's a current negotiation at the WHO on a pandemic agreement. And there's ongoing negotiations at WIPO on rights and measures to benefit the sharing of genetic resource and traditional knowledge. In all of these cases, I'll make there's interesting things to learn from. One is that, and I think Sean made this reference at the end of his presentation, it's relevant here. They begin by thinking of in the CBD in 1992, and so the early models were all the idea that you'd base the benefit sharing obligations on access to the materials, and then access, more recently, digital sequence information. And that's created a lot of problems in terms of its implementation. Some of the more recent negotiations at the BBNG and the Cali Fund have a different approach. They set the triggers downstream on things like filing of patents, registering products, and selling products. So they've gone from looking at the input, like access to knowledge, as the trigger, to selling products and commercializing as the trigger. And I think that's an important thing to think about when you talk about AI, in terms of whatever kind of triggers you have on benefit sharing that take in that place. Another thing I would mention in terms of the ABS negotiations was in the Cali Fund negotiations in the Convention on Biodiversity at COP15 in Montreal, in decision 15/9, and the 9th item, that's very, I'm sorry for all these little things, but I can share that later with the written version. But they have this is part of the framework that you'd have for designing a benefit and sharing agreement. And one of them is that you should provide certainty and legal clarity for providers and users of digital sequence information. So that's, I think everyone understands, is really important for AI training. They say it should not hinder research and innovation, whatever the regime is. You should be consistent with open access to data. That's another thing that they have in there. It should be efficient, feasible, and practical. Good advice, in my opinion. These are all things that Chile and other countries have agreed to as principles recently in COP15. And this is, I think, very important. It says you should generate more benefits, including both monetary and non-benefit, than cost. And this is something that is, in the past, is important because it's been ignored in a lot of the negotiations. A lot of the negotiations start out with, like, people have political demands, they have intentions, they want to solve all kinds of unfairness and historical injustices and things like that. And in terms of the sort of intentions are always awesome. The practical implementation are often problematic and sometimes very costly or impractical. So the idea that you have a condition that the benefit should really exceed the cost in terms of the implementation, I think is a really critical thing. Now, I could speak a lot longer, but I'm going to stop now because I know that you have other people you want to hear from, and you want to have time for question and answer. Thank you very much.
Thank you, James, for your brilliant presentation. Now, we I have to present our next speaker is Juan Francisco Reyes, an attorney and professor at the University of Chile, Faculty of Law, where he earned both his law degree and his master degree. He also holds a master from Stanford University. He's a partner at SCR Abogados, one of the Chilean's leading firms, and serves as abogado integrante of the Court of Appeals of San Miguel. His practice sits precisely at the intersection of intellectual property, technology, and business law, making him an essential voice in today's debates from the perspective of legal practice in Chile. Please welcome Juan Francisco Reyes.
Gracias, María José. Yo voy a hablar en español porque no me siento preparado para hablar en inglés sobre estos temas tan específicos, pero cualquier cosa pregunta específica que se haga en inglés también no tengo problema con contestar. Yo voy a dar un par de pasos hacia atrás respecto a las presentaciones que han hecho James y Sean. Yo voy a hablar un poco de dónde aplica la excepción, ya no tanto respecto de las consideraciones que se deben tener en cuenta o en vista a la hora de definir el alcance de una excepción de text and data mining, sino más bien en qué etapa del proceso se puede aplicar esta excepción y cuál es el efecto que esto puede tener. Yo entiendo que Luis luego va a hablar respecto a las consideraciones de política pública, específicamente respecto del ordenamiento jurídico chileno, así que no trataré de, o mejor dicho, trataré de no cruzarme con esos temas con que lo va a tratar con posterioridad. ¿Cómo funciona el entrenamiento de un modelo de inteligencia artificial? Esto es básicamente en distintas etapas. Hay una primera etapa que es una etapa de diseño, donde en esa etapa de diseño se selecciona una serie de datasets, de conjuntos de data, donde esos conjuntos de datos pueden contener distintas cosas. Pueden contener imágenes, pueden contener textos, pueden contener sonidos, pueden tener visualizaciones de personas. Entonces puede haber cosas que no estén sujetas a derecho alguno, como los hechos a los cuales referían Sean y James. Y también puede haber algunos que sí estén sujetos a algún tipo de protección, sea protección por normativa de datos personales, protección por derechos de autor, protección por derechos sobre la propia imagen, u otros derechos que eventualmente pudieran estar asociados a dichos datos. Desde la perspectiva del modelo, estos simplemente son datos, no discrimina en principio qué es lo que se incorpora en esta etapa de entrenamiento. O sea, estos datasets que se define por parte del desarrollador incorporar dentro del modelo en esta etapa de entrenamiento, no son técnicamente copiados, sino que son incorporados en la base de datos, donde hay una suerte de copia transitoria. Esa copia transitoria no califica dentro de la excepción del artículo 71 o de la Ley de Propiedad Intelectual en Chile, porque en principio esta no tiene la finalidad que se define a su efecto. Y es simplemente un proceso de carga donde luego el modelo lo que luego hace es parametrizar y tratar de identificar elementos comunes para efectos de poder proponer las soluciones que tiene. En esta primera etapa, que es este scrapping general de los datos, donde tienen luego una carga general y masiva de datos, donde esos datos luego son analizados y parametrizados por el modelo mismo, existe esta excepción de text and data mining, que es la que generalmente tiene por propósito que ese proceso se pueda desarrollar sin ningún tipo de cuestionamiento por parte de los titulares. Cuestionamiento que podría ocurrir porque si es que existe cualquier tipo de derecho respecto del dato, del objeto que está siendo cargado, eso pudiera eventualmente ser objeto de alguna objeción, y si existe alguna objeción, eventualmente podría frenarse o limitarse este proceso en términos tales que el desarrollo del proceso pues termine siendo más frenado o limitado o eventualmente bloqueado por parte del titular en una situación en la cual esto pareciera no ser razonable, atendido el resultado que se logra. Entonces, esta primera etapa de diseño, se definen los datasets que eventualmente van a ser cargados, luego de una etapa de desarrollo, donde hay ciertos elementos que van a ser incorporados dentro de la caja negra, si se quiere, del modelo, que es lo que va a permitir que esto funcione de la manera en que funciona. Todos pueden tener eventualmente los mismos datos, pero en esta etapa de desarrollo en la cual se va a definir cuáles son los resultados o la forma en la cual se van a crear los resultados, es la que puede ser un poco más determinante a la hora de verificar la calidad del modelo de inteligencia artificial que corresponde. Entonces, en este desarrollo que esta caja negra no tenemos idea qué es lo que mete el desarrollador. Pero ese desarrollador, y es razonable que no se sepa qué es lo que está en esta etapa de desarrollo porque es parte, comillas, de su propio diseño. Pero en esto pudiera eventualmente incorporarse también o bien reproducciones de obras de terceros, o bien reproducciones de extractos o adaptaciones de cosas preexistentes de terceros. O sea, hay algo que puede eventualmente también dar lugar a algún tipo de resultado por diseño que dé cuenta de una copia literal de algunas de las obras que fueron cargadas como parte de los datasets en la etapa de diseño. Y luego está la etapa de producción, donde en la etapa de producción tenemos la etapa del usuario final que accede al modelo y este usuario genera un prompt y a partir de ese prompt se genera un output que puede eventualmente tener algún tipo de similitud con alguna de las obras base que fueron cargadas en la etapa de diseño y o de desarrollo. Y aquí hay distintos cuestionamientos, distintas cuestiones que pueden tener lugar en relación con los derechos de autor. En relación con la etapa de diseño, como les decía, eventualmente estas copias transitorias que se hacen en el momento de la carga masiva de datos, puede haber algún tipo de reproducción que pueda tener algún cuestionamiento por parte de los titulares, y es lo que estas excepciones por regla general buscan eliminar. En la etapa de desarrollo puede haber memorización de parte de los resultados, y esta memorización puede dar lugar a resultados idénticos. Y eso significa que estos resultados idénticos van a dar lugar a copias o adaptaciones más adecuadas. Y en el caso de la etapa final hay temas tanto en relación con la titularidad de las obras, porque hay un cuestionamiento respecto a si estos resultados, estos outputs, son potencialmente apropiables, cosa que es debatida en distintas jurisdicciones con resultados diversos. Y por otro lado hay un tema de si estos resultados son adaptaciones, si eventualmente pueden ser, por ejemplo, cuando hay una noticia, alguien me resume una noticia, esto puede haber algún tipo de adaptación respecto a la obra original, o de algún artículo, me resume el artículo, esto puede ser algún tipo de adaptación, puede haber alguna forma de comunicación al público, en algunos los casos de las reproducciones o las rememorizaciones o los resúmenes puedan ser demasiado similares, y puede haber temas también de reproducciones, ya sea de imágenes, de sonidos, de tonalidades, de música, de un sinnúmero de aspectos que desde la perspectiva del modelo son datos, pero que desde la perspectiva de la titularidad de los derechos sobre los mismos pueden ser obras protegibles por derecho de autor o bien algún otro tipo de derecho. Ahora, ¿cuáles son los efectos de esta excepción? En realidad, los efectos que puede tener este tipo de excepciones son fomentar y facilitar el desarrollo de estas industrias, y así al menos lo han entendido localmente en términos de que cuando se proponen nuestras bajadas locales a la excepción de minería de textos y datos, lo que se está tratando de hacer es permitir el desarrollo de una industria en el sentido, sin que las limitaciones propias del derecho de autor u otros derechos puedan eventualmente bloquear el desarrollo de estas obras. Como mencionaba James, hay distintas alternativas respecto de cómo puede eventualmente solucionarse o puede, mejor dicho, definirse esta excepción, pero el punto es que cuando se determina la existencia de una de estas excepciones, lo que se está haciendo es permitiendo una salida, como mencionó María José, un safe harbor inicialmente respecto de los eventuales derechos de autor. Y si en ausencia de la misma entramos en una situación de potencial infracción, y en esta situación de potencial infracción tenemos luego una complicación adicional desde que el eventual desarrollo del modelo puede comprometer algún tipo de responsabilidad para aquel que lo desarrolle, y si es que eso supone algún tipo de responsabilidad, pudiera también eventualmente suponer algún bloqueo del uso de la plataforma o del modelo en algún punto previo incluso a su lanzamiento, y eventualmente un desaparecimiento de este emprendimiento. O sea, hay una idea de fomento al desarrollo de esta industria, y este fomento del desarrollo de la industria es lo que determina la necesidad de implementar, o la conveniencia de implementar algún tipo de excepción por esta línea. La postura contraria es, bueno, si es que tenemos estas excepciones, estamos limitando los derechos de los titulares de los derechos, valga la redundancia. Y en ese sentido, al limitar el alcance de estos derechos, estamos expropiándoles en cierta medida sus facultades, o privándolos de sus facultades para controlar el uso de los mismos. Y aquí hay un trasfondo que quizás viene más por el lado de el reemplazo de las labores creativas desde un humano hacia un modelo, y por lo tanto una disputa que quizás va mucho más allá de lo que hoy día estamos discutiendo, pero que justifica hoy día el debate de la perspectiva chilena. Soluciones como las que han propuesto me parecen ser convenientes, pero dan cuenta también de la disparidad de criterios que existen en las distintas jurisdicciones, y por lo tanto de una realidad práctica, que es que eventualmente este desarrollo que pudiera hacerse en Chile sobre la base de el diseño de un modelo, eventualmente puede verse enfrentado a realidades distintas en los distintos países donde ellos eventualmente busquen explotar comercialmente su modelo, y eso puede redundar también en alguna potencial asunción de riesgos que un poco prescinde de la regla local. Vamos a tener que tener en cuenta no solo un mapa de qué es lo que ocurre a nivel del lugar en el que se desarrolla el modelo, se implementa efectivamente etapa de diseño, que es donde tiene su principal aplicación, pero también eventualmente pudiera ser objeto de cuestionamiento en otros lados, dada la dispersión normativa que existe en relación con este punto. Creo que eso es lo que tenía preparado, así que podemos seguir con el siguiente presentador. Muchas gracias a todos por su tiempo.
Thank you, Juan Francisco. Our final speaker brings a perspective that is in many ways unique in this room. He has shaped Chilean copyright law not only as a scholar, but as negotiation, a regulator, and international decision maker. Luis Villarroel holds a law degree from the Universidad de Chile and an LLM from the Washington College of Law, the same institution represented today by Professor Flynn. He served as intellectual property advisor to Chile's Ministry of Education, as vice president of WIPO's Standing Committee on Copyright and Related Rights, the very body where today's debate plays out in the international level, and as a member of APEC's expert group on intellectual property. He also served as Minister of Chile in Industrial Property Court. Most significantly for today's discussion, Mr. Villarroel led the negotiation of the copyright chapter of the Chile-United States Free Trade Agreement and participate directly in drafting the copyright exception enacted in Chilean law in 2008. In other words, the legal constraints we are discussing today, he helped to write them. Please welcome Luis Villarroel. You are mute, Luis.
Bueno, muchas gracias, María José, por la presentación. Desde luego lo que voy a hablar ahora es mi opinión personal y no está vinculado a mis ex empleadores, así que es de mi experiencia. Voy a compartir una PPT que me va a ayudar un poco a ir ordenando el proceso. Entiendo que tengo 12 minutos, ¿no?
Yes.
Entonces, vamos a dejarla. Entonces, yo creo que, bueno, han sido fantásticas las explicaciones de mis antecesores, tanto como Juan Francisco, James y Sean han dado una visión muy clara de las distintas tendencias que son a nivel internacional y también de cuestionamientos que se hacen a la legislación chilena. Yo quisiera aportar con algunas consideraciones adicionales de política pública que informan una propuesta que voy a hacer al final de cómo se podrían tomar en las piezas que ya ha explicado muy bien Sean, ¿no? ¿Cuál sería mi receta? ¿No? Entonces, pero a las consideraciones que tengo en mente para llegar a esa propuesta es, en primer lugar, que la inteligencia artificial, como ya todos sabemos, es un tema de desarrollo económico, de promoción de nuevas formas de creatividad, pero lo que para mí es más importante es un tema de seguridad nacional. O sea, estamos hablando en una situación que tenemos una herramienta que es clave para cómo será la nueva civilización, la civilización que va a estar completamente inmersa en la inteligencia artificial. Entonces, es extremadamente preocupante desde el punto de vista de la política pública, un hecho que ha sido destacado incluso por el Papa, la concentración que tiene en pocas manos y en pocos países este instrumento. Y estamos en una situación de que ya esta inteligencia artificial ha sido desarrollada de una manera muy potente y ya es muy difícil lograr llegar para un terceros actores equiparar estas capacidades. Entonces, pero igual tenemos que generar capacidades nacionales, instrumentos nacionales que nos permitan de alguna manera hacer menos fuerte esta dominación y este peligro que tenemos de estar sujetos a inteligencia artificial que es controlada por terceros. Hay ejemplos muy claros que hace muy poco Estados Unidos prohibió la exportación de ciertas inteligencias artificiales a cierto nivel de cloud, lo que demuestra que esto no es algo teórico, está la posibilidad de que en un minuto un país pueda cortarle la llave a la inteligencia artificial a Chile y eso generar una disrupción brutal en nuestra sociedad. Pues otro punto que es fundamental es que hoy día ya se está haciendo un uso de las obras, incluyendo las chilenas, sin que haya una compensación. O sea, no estamos pensando en cómo evitamos que algo pase. Es algo que ya está pasando y independiente de lo que hagamos nosotros como país, va a seguir ocurriendo, porque ya hay países que tienen excepciones que están establecidas muchas de ellas que no tienen compensación. Entonces, no, estas grandes plataformas que tenemos acceso en Chile desde el extranjero, que están nutridas incluyendo las obras chilenas, van a seguir existiendo. Entonces, tenemos ahí un tercer desafío. Otro desafío y otra cuestión que tenemos que pensar es que en realidad el uso que se hace a las obras en el contexto del entrenamiento de inteligencia artificial es un uso que es completamente innatural o desnaturaliza el uso que conceptualmente se tiene de una obra. O sea, una obra está destinada a comunicar expresión o expresar ideas, generar sentimientos, generar opiniones en otra persona. Y ahí es lo que, bueno, que hablamos del uso consultivo de la obra, pero en el caso de la inteligencia artificial, o sea, al menos en lo que se refiere al entrenamiento, ahí ya no está, digamos, esa finalidad, sino que es una completamente diferente, que es el servir de datos para una máquina. Entonces, eso sin duda no es lo que se tenía en mente cuando hablábamos de una obra. Entonces, eso crea cuestionamientos también sobre la suficiencia del actual derecho de autor para hacerse cargo de este tipo de uso. Y por último, estoy plenamente convencido que es necesario que quienes aportan al proceso de entrenamiento de una inteligencia artificial y que va a tener un uso comercial, tiene que de alguna manera tener algún tipo de retribución que venga a compensar en algunos casos la sustitución inevitable de algún tipo de obras o algún tipo de servicios, pero como también digamos, es un principio, ¿no es cierto?, de justicia que me parece casi natural, ¿no?, de derecho natural. La otra idea que me parece importante recordar es que, porque a veces he escuchado en otras discusiones la idea en cuanto a que el derecho de autor, las normas internacionales de derecho de autor, incluso las nacionales, establecen una facultad al titular del derecho de autor que aplica respecto de todos los usos de una obra. Y eso es un error jurídico, porque el convenio de Berna y después los tratados de la OMPI y pasando por el tratado de la OMC son taxativos en en las facultades que se otorgan al titular del derecho. Y eso es tan obvio como pudimos ver cuando se apareció la Internet y aparecieron nuevas formas de utilización y la digitalización que no estaban contemplados dentro del convenio de Berna. En consecuencia, el resultado fue que fue necesario generar otro instrumento que, digamos, que se hiciera cargo de estas nuevas formas de utilización. Y tal vez yo creo que eso es un poco lo que va a pasar con el derecho de autor y la inteligencia artificial. Nada más entendiendo que hay audiencias muy diversas en términos de la experiencia que tienen en materia de tratados internacionales de derecho de autor. Les voy a dar algunos ejemplos de los derechos que hoy día nos parecen como casi naturales de derecho de autor, pero que no estaban dentro del convenio de Berna y que fueron necesarios a partir de estos nuevos usos que permitía la digitalización. Por ejemplo, el derecho de puesta a disposición. Fue necesario modificar el concepto de comunicación al público, desnaturalizarlo para permitir que se considerara que una transmisión que se hace a una persona en particular en su casa a las 7 de la tarde, eso era una comunicación al público, cuando históricamente la comunicación al público estaba asociado a una transmisión que se hacía a múltiples personas. Entonces, esto lo hago para ilustrar que el derecho de autor ha tenido que irse, digamos, ampliando para incorporar nuevas formas de utilización. Ahora, pero a pesar de que se trató en el Tratado de la OMPI del 96, incorporar y satisfacer, digamos, los vacíos que habían con relación a los uso de las obras de manera digital y de Internet o por Internet, no hubo estos cambios no fueron plenos. Y hubo un punto que es fundamental para efectos de determinar la flexibilidad que tienen los estados para regular el tema de las reproducciones que se hacen en el ámbito de la inteligencia artificial. Y ese punto que es tan clave ahora es si se iban a considerar o no como parte del derecho de autor las reproducciones temporales. Recordemos que, de acuerdo con el convenio de Berna, existe en el artículo 9 el derecho de reproducciones, pero no hay un consenso en términos si esas reproducciones pueden ser o no temporales. Y por eso, en el convenio de la OMP y el WST, en la propuesta de negociación que fue discutida, se incluía una norma expresa en la que señalaba que la reproducción incluía tanto la permanente como la temporal. Y esa norma fue rechazada en la negociación, porque los países querían tener, digamos, flexibilidad para ver cómo resolvían esta situación de las nuevas formas en el ambiente digital. Entonces, y como situación digamos, como solución de consenso, o digamos que para incorporar de alguna manera el tema de la reproducción digital, a lo más que se llegó fue a una declaración concertada que señalaba que el almacenamiento digital constituía una forma de reproducción, pero ya no como una norma sustantiva, sino que como una declaración concertada que, dado que no fue adoptada por unanimidad y tuvo una alta abstención, más una serie de países que se opusieron, hace que digamos, esa declaración concertada, que a veces lo tomamos como si fuera una norma sustantiva, tenga un valor muy limitado en términos de interpretación, porque no constituye una norma de consenso. El otro punto que también es importante y que a veces se omite es que dentro de los tratados de derecho de autor existe un principio que va implícito, que es que estos derechos privados que se establecen tienen que estar supeditados al orden público, al interés público. Y eso lo encontramos ya desde en la conferencia diplomática del año 1896, donde se establece y queda en las actas que que el propósito de la Convención de Berna, que es regular derechos privados, de ninguna manera debe interferir con el derecho de regulación que tienen los estados. Entonces, eso garantiza que en la interpretación que se haga de las normas del Convenio de Berna, incluyendo la regla de los 3 pasos, implica que se le tiene que dar una valoración y una deferencia a lo que es el interés público. Y ese interés público se refleja de manera expresa que el Convenio de Berna tiene 11 excepciones que son no remuneradas, 5 posibilidades de licencias obligatorias, 4 limitaciones que permiten la exclusión completa de la protección. Por ejemplo, en el caso, está la posibilidad que establece el artículo 2 que se excluya la protección de las obras que no han sido fijadas en un soporte material, que es un punto que es clave para, digamos, para definir una estrategia que pueden tener los países para limitar ciertos usos digitales en los cuales no hay una fijación. Entonces, ¿cuáles son los espacios de flexibilidad que tiene el ordenamiento internacional? Digamos, focalizándonos en algunos que son relevantes para el inteligencia artificial, es, bueno, la posibilidad que tienen los países de excluir protección a las obras que no están fijadas de manera material, y también el artículo 9 del Convenio de Berna establece el derecho a reproducción, y se ha interpretado el derecho a reproducción como una fijación sobre un soporte. Eso en el Convenio de Berna. Entonces, cuando hablamos de las copias digitales, nos encontramos que se tratan no de fijación en soportes materiales, sino que son unas, digamos, representaciones alfanuméricas, o sea, de unos y ceros. Entonces, ahí para algunos autores, eso demuestra que y eso sumado a esta falta de consenso en términos del almacenamiento digital, que los países tienen una libertad en términos de definir cuál es, digamos, la protección que puede haber respecto de una copia digital. Recordando que la definición de fijación no está a nivel internacional para los derechos de autor. Hay una definición de fijación que va contrario a lo que estoy diciendo, pero es solo aplicable al Tratado de Derechos Conexos. Por el tiempo me voy a saltar esta slide y para ir, para llegar a la propuesta que les quiero proponer, me quiero detener unos minutos en la regla de los 3 pasos. La regla de los 3 pasos, como todos conocen, se refiere a una norma que viene del Convenio de Berna, en el artículo 9, número 2, que se incorpora como una manera de permitir las excepciones al derecho de reproducción en el año 67, que es cuando se incorpora el derecho de reproducción en el Convenio de Berna, pero es una regla que tiene aplicación cuando no hay otra norma dentro del Convenio de Berna que establece una posibilidad de excepción al derecho de reproducción para un fin especial. Por ejemplo, el caso del artículo 10, número 1 o 10, número 2, referidos a citas o de ilustración para la enseñanza. Entonces, es una norma general que tiene que convivir con otras normas específicas. Ahora, la dificultad de esta regla es que los pasos tienen conceptos que pueden tener diferentes interpretaciones. Y no voy a entrar en esto por el tiempo. Y de manera tal de que hay, digamos, mucho margen político-jurídico para adoptar, digamos, una interpretación. Y lamentablemente, desde el punto de vista de las normas internacionales, hay muy pocos precedentes para encontrar interpretaciones de autoridad en esta materia, y la principal, que es la que ha servido para informar la doctrina y ciertas prácticas, es una sentencia, por así decirlo, del Tribunal de la OMC. O sea, en realidad no es un tribunal, pero es un panel que es la que se refiere al juicio entre Estados Unidos y la Unión Europea sobre la sección 110 de Copyright Act, que se refiere a la excepción para la música en los bares. Bueno, resulta que esa sentencia, que se ocupa como base de muchas interpretaciones de la regla de los 3 pasos, es una sentencia que no se refiere a un tema de interés público o de orden público, como podría ser la inteligencia artificial. Segundo, es una resolución que no fue apelada. de manera tal de que si hubiera ido al órgano de apelación de la OMC, podría haber cambiado. Y normalmente cuando ha ocurrido una apelación, cuando había órgano de apelación, tenía modificaciones. Y lo otro que hace todavía más débil es que es una resolución que no ha sido cumplida por las partes que estaban, que fue condenada, que en este caso Estados Unidos, que fue condenado a modificar su legislación nacional. Ya han pasado 25 años y no muestra ningún interés en hacer una modificación. Entonces estamos hablando de una sentencia que ni siquiera fue cumplida por las partes. Entonces, bueno, en base a todo lo que he dicho, sin duda es necesario una nueva norma internacional. Pero por tiempo vamos a saltarnos eso y para ir a la propuesta. Una norma de excepción para Chile, creo que es fundamental que, siguiendo el modelo europeo, haga una distinción en cuanto a la gente que hace, digamos, el entrenamiento. Público versus si es una entidad comercial. También parece fundamental que se haga una distinción dependiendo de la finalidad de la inteligencia artificial que se está siendo desarrollada. No es lo mismo una inteligencia artificial que está siendo desarrollada para fines, digamos, resolver un problema de salud pública o de cambio climático u otro, a una inteligencia artificial que está siendo creada para sustituir o que va a tener evidentemente resultados de sustitución de obras audiovisuales o literarias u otras manifestaciones artísticas que están en otra categoría, digamos, de interés público. También es fundamental distinguir el alcance que tiene esa aplicación y el tipo o tamaño de la gente que lo hace. Cuando se tratan de agentes que son comerciales. No puede ser lo mismo una startup chilena que una plataforma global. También tiene que haber una distinción atendiendo del contenido que predominantemente se utiliza. Y por último, la solución debe considerar mecanismos que focalicen las compensaciones o retribuciones a el sector de los artistas nacionales. Entonces, ahora, ¿cómo resolvemos el tema de la focalización para los artistas nacionales? Ya lo había un poco adelantado, James, nos encontramos con que si la solución de la compensación está asociada al derecho de autor, nos va a aplicar la norma de trato nacional. En consecuencia, del 100% que se utilice de las obras chilenas, o de las obras, digamos, mundiales por un desarrollador chileno, lo que pague, por ejemplo, un startup chileno, el 99% va a salir al extranjero porque, desde luego, la incidencia que tiene las obras chilenas dentro del contexto general y mundial no alcanza al 1%. Entonces, la idea es que encontremos una fórmula que permita que lo que se cobre, a quien se cobre, quede a nivel nacional. Una alternativa que me parece que estaba bien orientada en el proyecto de reconstrucción, aunque muy mal diseñada y mal explicada, es que debería haber un fondo nacional para creadores de contenido que se alimente en base a impuestos específicos a las grandes plataformas o las plataformas que suben, están en un cierto rango de ventas. Y también eso convivir con un derecho de de remuneración o de gestión colectiva de algún derecho sui generis, siguiendo el modelo que nos contaba James Love. Con esto dejo porque necesitamos tiempo para las preguntas.
Thank you, Luis. We have some questions in the chat, but these questions was already answered by the panelists. So we think that it will be better if we can close this seminar with if you want, of course, one of everyone can speak 60 seconds with one just key idea or takeaway for the audience for all the things that you say, and with that we leave that today. If you want, Sean, you can start with that.
Sure, I'm happy to. I mean, I think the key focus of my intervention is that fashioning these kind of rules are actually pretty complex, and reaching a balanced solution requires considering a number of elements. One of the options, of course, is to put those elements directly into the exception. You know, this makes any exception look a little bit more like, for instance, the US Fair Use Standards, where it gives a number of different criteria that can be applied to the exception. So you could imagine, for example, an exception for text and data mining purposes that only extends to uses that don't substitute for the work of the author, and you know, and in consideration of any public interests and the type of the user, etc. You know, you could have some different factors that could be gone between. I think actually working these things out in legislatures tends to reach to solutions that are not complex enough in many situations. You know, if you look at the Indian statutory license, it just applies to all generative AI. The Brazilian proposal just applies to all generative AI. And these terms, generative AI is a pretty mushy term. There's a lot of public interest research projects that are basically using the same tools. So it's a complicated area. So I'll stop there. Thank you very much for having me, everyone. It was a pleasure to meet you and to be part of the discussion.
Thank you, Sean. James, your closing thoughts?
Well, I think it's great that you convened this meeting, and I really learned a lot from all of the presentations. I think that this is a time to be creative in terms of how you approach things. I think you need to focus in terms of any, I think you need two things. You need like a very robust exception for people trying to develop AI services. And you need some way to provide some remuneration to certain sectors of copyright holders that have the most compelling reason to be compensated. You don't want to do something that's like overly broad and going to create more problems than it solves. But I think you can do that. There's some, I think, models you can look to that are related to, or in some cases a little outside of copyright per se, which would be really helpful. Thank you very much.
Thank you, James. And Juan Francisco, your closing thoughts too?
Gracias, María José. Yo creo que la excepción es algo que debe contemplarse. En ausencia de una excepción, efectivamente estamos generando un bloqueo a una industria es emergente y que no se va a ir. Tenemos que el balance de intereses de los privados en relación con la misma es algo que debe ser tenido en cuenta, pero entendiendo que las consideraciones de corto plazo y largo plazo van a cambiar. Y en ese sentido, la regla que se adopte debe ser cuidadosa para efectos de poder permitir que por un lado se pueda desarrollar esta industria y por otro lado los derechos de los titulares que hoy existen no se transformen en un obstáculo para desarrollo futuro. Muchas gracias a todos por la participación y gracias por la oportunidad de participar en esta TICAS.
Thank you, Juan Francisco. And Luis?
Definitivamente necesitamos una excepción, independiente de que uno pueda argumentar que ya hay excepciones o que hay ciertos usos que no están contemplados en el derecho de autor. Necesitamos certeza jurídica y por eso debiéramos ser creativos y flexibles, entendiendo que al final del día que Chile tenga el desarrollo de inteligencia artificial es tan beneficioso para artistas como para el resto de la sociedad. Entonces, no hay aquí una cosa que no le va a ser útiles a los autores, a los artistas, porque el proceso creativo ya se hace también combinando, ¿no es cierto?, los instrumentos. Pero obviamente hay que ver una compensación cuando ese uso es comercial, lo que es el uso por entes que son públicas o universidades, creo que tiene que ser libre para el entrenamiento lo más rápido posible del instrumento que necesitamos en Chile.
Thank you, Luis. Before closing the session, Alberto wants to say the final words.
Well, thank you very much to all of you for accepting being part of the conversation. Thank you, Luis, for suggesting the idea of bringing us together to have this conversation. James and Juan Francisco and Sean, thank you for the different approach that you have suggested. I was particularly called by the argument of Sean regarding to the fact that artificial intelligence is being unevenly spread across the world, is unevenly developed, access across the world, and to some extent that is due to the fact that there is not appropriate copyright exceptions in many jurisdictions. James always have more complexity to the analysis by making us conscious that it's not just about copyright, but it's also about data privacy regulation. But it is possible to explore solutions that prevent what has happened in the case of Chile with the 2 rejections by the Congress of the 2 bills introduced by a leftist government and a right-wing government. Still, both of them rejected because of the lack of due consideration for compensation when that may be necessary. But also calling the attention about the data protection, so that the protection may be a challenge for us in implementing solutions for artificial intelligence, especially when we don't pay appropriate consideration to the access to data for research. Juan Francisco, thank you very much also for making us clear that it's not just about the input that is necessary for working with these devices. This is maybe also the challenge for the output, for the result of using these devices, this technology. And we need to pay attention to the fact that may not be covered by a current copyright exception. But in any case, it's something that we need to consider in the discussion. And Luis include another complexity to the analysis by calling to our attention about the fact that this is not just about copyright regulation. This is not just about development. It has a lot of implications also for digital sovereignty, which is something that then connect very nicely with the recently introduced bill to modify the constitution in order to ensure and impose on the government the obligation to work for digital sovereignty. Thank you very much for all of that, for all your wonderful comments. I took thousands of notes, and I'm not sure I will be able to bring it back to our conversations, but I'm looking forward to somehow work with them. And I want to also give thanks to our moderator, Maria Jose, or Maria de Los Angeles, who has been acting as a welcoming providing the welcoming words, and our translator, who has been Esteban, doing fantastic work, as far as I can notice, in making us understand what is going on here. And thanks to the audience, especially for the passion that you have had in waiting for 15 minutes until we could figure out all the technical challenges associated with work. Thank you very much, and I look forward to stay in contact with you and to continue the conversation in another opportunity.
Thank you, Alberto. I want to thanks to our speakers, Professor Flynn, James, Juan Francisco, Luis, for a great conversation that has illuminate both the complexity and the urgency of this issue. So I hope the audience will be happy, and we end this seminar with new knowledge and new questions and opinions that will help for Chile to the window for shaping these norms. Maybe domestically remains open. So thank you all for joining us, the CE3 team. Thank you, Alberto, for choosing me for moderate this seminar, and we'll share the recording and materials eventually shortly. Have a good day, everyone. So take care, and thank you for the instance.
Gracias, María José. Adiós.
Chao, muchas
Bye-bye.
gracias.
Thank you. Bye.
Bye.